Counsel, I know your argument is basically a Bantam book argument, but do you need coercion in order to, do you think that's the only way you could make your case? Or could coordination accomplish the same thing? That is, the government is censoring by joint actions with the platforms as opposed to coercing the platforms?
Your Honor, we don't need coercion as a theory. That's why we led with encouragement in our red brief. And I would point the court to what it said in Norwood, which is the court or the government cannot induce, encourage, and promote private actors to do directly what the government can't itself do directly. And that's, I think, the principle that's guiding here, which is regardless of the means that the government tries to use to pressure the platforms to commit censorship against third parties, the Constitution really doesn't care about that. It's the fact that what the government is trying to accomplish is the suppression of speech. And I would say, Your Honor, I mean, that's exactly how you address this question in Bantam Books. You asked, did the government set out to deliberately suppress speech? The answer in that case was absolutely yes, and that's absolutely the answer in this case here. And I guess, I would say, when this court considered Bantam Books, one of the key things about the analysis in Bantam Books was that it was an obscenity case. And, the court struggled with whether the states had the right to police the line between legitimate speech and illegitimate speech. And that was why you were talking about coercion in that case. You were asking whether the states
I'm sorry. The reason we were asking about coercion is because the private parties could have chosen on their own to censor that speech. They could have said, we think it's obscene, I'm not going to be involved in this. The only issue became when that choice was overwritten by the government. And so I think you're mixing sort of situations and confusing legal doctrines.
No, Your Honor, the fundamental principle, and this comes from Norwood and it's central to this court's First Amendment cases, this Fourth Amendment case, is that the government can't do indirectly what it's prohibited from doing directly. And that's what you see happening in Bantam Books, that's what you see happening in a case like this. Because time and again, there were times where the social media platforms had policies that didn't go far enough in censoring the speech that the government wanted them to censor.
But whether or not the government can do this is something I took up with Mr. Fletcher, depends on the application of our First Amendment jurisprudence, and there may be circumstances in which the government could prohibit certain speech on the internet or otherwise. I mean, do you disagree that we would have to apply strict scrutiny and determine whether or not there is a compelling interest and how the government has tailored its regulation?
Certainly, Your Honor. I think at the end of every First Amendment analysis, you'll have the strict scrutiny framework in which, in some national security hypos, for example, the government may well be able to demonstrate a compelling interest, may well be able to demonstrate
All right, so not every situation in which the government engages in conduct that ultimately has some effect on on speech necessarily becomes a First Amendment violation, correct?
Maybe not necessarily, Your Honor. I guess the top line question I would ask is, has the government set out to abridge the freedom of speech? And in this case, you see that time and time again, because if you control
That's not the test for First Amendment violations.
Your Honor, this flows from the plain text of the First Amendment, right?
No, I understand, but we have a test for a determination of whether or not the First Amendment is actually violated. So in certain situations, the government can actually require that speech be suppressed if there's a compelling interest, right?
It can, Your Honor, and I guess what I would say is that the courts below never got to strict scrutiny because the government never raised this. This has never been litigated. The question in this case is whether at the front end the government itself has undertaken action.
Is the coercion, is the state action, right? That's the question in this case.
And I would urge the court to address the state action issue just like you addressed it in Bantam Books. Use that term 4 times in Bantam Books.